Our first speaker is immigration and criminal lawyer Terry Fisher. Terry has helped numerous refugees on numerous occasions with applications, appeals and much more. Please make Terry welcome.
Good morning. I wish to acknowledge that we stand on the stolen lands of the Jagera and Turrbal people. The Migration Amendment Removal and Other Measures Bill 2024, otherwise known as the Removal Bill, is tied up with the constitutional question as to whether or not the Migration Act allows the indefinite detention of Australian non-citizens. The 2004 High Court decision Al-Kateb found that indefinite detention was lawful. The decision lacked adequate jurisprudential reasoning. In November 2023, the High Court in the decision of NZYQ was handed down. It held that it was unlawful for the Australian government to continue to detain a person in immigration detention where there was no real prospect of the person's removal from Australia. The decision affected only a limited cohort of persons who must be both stateless and have engaged Australia's protection obligations. In other words, found to be a refugee or cannot be returned to their country of origin because very clear human rights abuses would occur. 140 persons were released from detention, and immediately preventative detention legislation was rushed through the Parliament, allowing the Minister to subject people to electronic monitoring, curfews, conditions restricting their conduct and movement. These measures would not apply to any Australian citizens that had completed prison sentences. On 26 March 2024, the Labor government introduced into Parliament the Removal Bill. The government had hit the panic button as it expected to lose the High Court case of ASF 17, in which the indefinite detention power was being considered. The proposed Labor Party legislation had two main aims. First, to force a person to cooperate with being deported from Australia, and secondly, to allow the Minister for Immigration to prevent people from certain countries from coming to Australia. Currently, as you've heard, the bill was shelved and is due to be debated again, as I understand it, next week. The ASF 17 case concerned an Iranian detainee who the government said was being lawfully held and could be deported if he cooperated with the efforts to remove him. The issue in the ASF 17 case was whether or not the limitation on detention applied to a person who did not have a formal protection finding but could not be removed to country of origin as it did not accept involuntary returnees, and the returnee did not consent to return. The High Court delivered its decision on 10 May 2024 and unanimously ruled that the Australian government can keep asylum seekers in immigration detention indefinitely in cases where they do not voluntarily cooperate with their own deportation. This includes, for example, when a person refuses to apply for travel documents due to a long-standing fear for their life if returned to their country of origin. At the crux of the ruling is the legal fiction that indefinite immigration detention can remain non-punitive and legitimate if a person is detained for the purpose of their eventual removal from Australia, even if the human effects of this detention are harmful and experienced as punishment. The Removal Bill goes much further than the High Court decision in ASF 17 by making refusal to cooperate in deportation or removal a criminal offence. The Law Council of Australia has criticised the Removal Bill. Some of the things it said are as follows. The bill is highly disproportionate and punitive in its effects on predominantly vulnerable individuals. We consider that the migration system will lack integrity if not based on Australia's international obligations and law. Not only would people face deportation even where they have genuine fears for their safety, but under this bill there is a very real possibility that the process of issuing a direction itself creates a situation of real risk of harm to individuals removed to that country, even if such risks may not have previously existed. Under this legislation, non-compliance with directions given is an offence, with a maximum penalty of 5 years imprisonment and a mandatory minimum of 12 months imprisonment. These are vastly disproportionate responses to a failure to comply with directions which may involve minor conduct which is not harmful or dangerous. The Council went on to say the ability to direct parents to act on the child's behalf with no legislative safeguards for consideration of what is a child's best interest being taken into account other than considering whether they can be removed with the family unit together. Now, this would put a parent in a situation that was concerned about their children going back to the country of origin, that they would suffer harm, ending up in jail for 12 months. But the reality is they could keep jailing you under this legislation. A person could be in our system, in our jail system, indefinitely. In other words, you could get multiple charges and multiple terms of imprisonment. Now, some of the characteristics or elements of the ASF 17 case were that the applicant was a bisexual Iranian man who had been held in closed immigration detention in Australia for more than 10 years. Although Iran criminalises homosexual activity, ASF 17 was found not to be a refugee under Australia's fast-tracked asylum claim process, which many experts have deemed to be flawed and discriminatory. And having been involved in acting for people in this process, I can tell you that it lacks procedural fairness to a number of the cases that I've seen, the substandard representation and substandard decision makers. The Attorney General Dreyfus has been wanting to replace the AAT system because he has said it's irreversibly damaged by political affiliated appointees. Now, for the most part, all these political affiliated appointees are still there making decisions. Nothing has changed since the ALP has got into power. The applicant in ASF 17 had refused to seek the required travel documents from the Iranian government. He had good reason for not cooperating with his own deportation. He had feared for his life if he returned to Iran, and in evidence he said, "I wouldn't have stayed in this camp for 10 years if I didn't fear that I was going to die." The applicant was prepared to be deported to any other country other than Iran. The Australian government acknowledged that there was no reasonable prospect of him being sent anywhere else. Iran would not have allowed him to return, as it does not take involuntary or forced returnees. It does not accept them. Yet the court found that there was a real prospect of the applicant's removal because it depended on him, on his conduct. The insanity of all of this, of course, is Australia has, in the Iranian situation, Australia has imposed sanctions against members of the Iranian regime responsible for human rights abuses and violations. In 2022, a Senate committee report recommended the Australian government increase the number of visas offered to Iranians, with a particular focus on women, girls and persecuted minorities seeking to escape the regime. Iranians in Australia on temporary visas who cannot safely return to Iran due to the current crisis and policies of the Iranian regime. And one of the effects of this bill is that Iran's considering accepting involuntary returnees because it's concerned that its own citizens won't be able to travel to Australia. So that's a great effect. Thank you.